morning, everybody. I'm going to stick my head in so that you see somebody's talking and it's not distracting. I'm Amy Gamber, and welcome to the webinar today. This is going to be our TREC update. I'll do a couple of administrative items quickly. The webinar is about an hour long, and we have been approved for CE credit, as those of you we can see know. If you want to receive CE credit, you must be at a local board office or some other location with proctoring. If you have technical issues with Zoom, I'm going to give you the phone number for Zoom tech support. Please don't call TAR with questions about tech support for the webinar format because we are not qualified to handle that. But the tech support number at Zoom is 888-799-9666, extension 2. Everybody who's watching the webinar is going to be muted. If you are at a local office participating for credit, wave at us if you have a question. We'll unmute you so that you can ask. If you aren't at a local board participating for credit and you have questions, you can type your questions into the question box, which you will find if you mouse over your screen. Some icons will pop up at the bottom of the screen, and there will be one for questions in chat. I will follow along, and we will either answer your questions as we go or at the end of the presentation, depending on time. We're recording the webinar, and we'll be posting a link to the video in various places. So keep your eye peeled for that. Hopefully it will be on the YouTube channel by the end of the week. Our presenters today are two lovely people who most of you know because they are two of our attorneys here at TAR, Kinski and Abby Lee. Many of you know them. Kinski and Abby are going to go over advertising rules and then some other things that have come up with TREC lately. They'll talk to you, and then after they are finished, I will pop back up to close things out. If that's all we have, I guess Kinski, take it away.
I think Ann Medford may have had a question. Did you have a question from that office?
Let me unmute you guys. All right, no, there's okay. Head shaking. Okay, great.
So if for some reason we don't hear you or see you, just raise your hand or put up a paper and we'll get to you. So again, I'm Kinski Moss. I am one of the TAR attorneys. There are 7 of us total. And just to give you a little intro into what the legal department does, in case you've never called the legal hotline, all the legal articles, the blog posts, professional standards hearings, we act as the hearing officers for those. All the legal FAQs, we write those. And also all the TAR forms, so the property management forms, residential leasing forms, and commercial forms, the TAR attorneys are responsible for those. How many of you, just by a show of hands, have called the TAR legal hotline? Just 2 people? Okay, so our TAR legal hotline is open to all realtor members of the Texas Association of Realtors, and all 7 of the attorneys do answer those questions. And this year, we're expected to reach, I think it's about 26,000 calls this year. We end up having about 100 to maybe, actually 60 to 100 calls per day. So if anything comes up today, feel free to contact me if you have a question about or contact the legal hotline. But I'm going to go ahead and get started. So on your screen, you should be able to, let me have Amy click over to the PowerPoint.
Yes. Nope, sorry.
Okay, give us just a second to show you the PowerPoint.
There you go. All right. Can you guys see the PowerPoint now?
Okay, perfect.
Okay.
Clicker's not working though.
Do you want this?
Yes. Okay, perfect. Thank you. And if you need it back, let me know. Okay, so today we're going to talk about a TREC update. I'm going to mainly talk about, and hi Lubbock, I think we just had you join us. So I'm going to provide an update on the new advertising rules that take effect in May. And then Abby Lee's going to talk about the consumer protection notice and the information about brokerage service updates, as well as possible certifications coming up at TREC. So here on the screen, we're going to talk about the applicable rules and regulations, the new definitions, advertising do's and don'ts, social media and text messaging, team names, and question and answer. But I do want you to ask questions throughout the presentation. So you don't have to wait till the end. Just raise your hand or hold up a card and we can get to your question. So why are we talking about advertising today? Well, not only has TREC proposed rules that will take effect May 15th of this year, but also TAR handles the professional standards process for across the state for all the local boards. And Article 12, which deals with advertising, 80% of our complaints happen to deal with Article 12 here at TAR. On the other hand, at TREC, the complaints dealing with advertising are about, I think it's 6 to 8%, so a lot lower. But also we're talking about advertising because the rules can be complicated, and under the current rules, there were a lot of safe harbors that are not exactly in the rules. So you may have heard us talk about the use of the term realty as an identifier. That was never in the rules, but it was adopted as a policy that you could use that as an identifier. Again, I'll get into the identifiers in just a second, but just want to go through the rules that will take place May 15th, coming up next month. So again, feel free to ask questions throughout the presentation. Okay, so what rules and regulations apply to advertising? You have the Real Estate License Act. You have 2 TREC rules under the new rules, so 535.154 and .155. Currently, you just have 154, but under the new rules, there's a new 535.155. And then if you're a Realtor member, you have to also abide by Article 12 of the NAR Code of Ethics, which applies to Realtor members. We are not going to cover fair housing, MLS issues, or federal law during this presentation. We're mostly going to focus on these 3 regulations and components on advertising. So who do these apply to? The first 2, the Real Estate License Act and TREC rules. It doesn't matter whether you're doing commercial, farm and ranch, property management, or just residential. The Real Estate License Act and the TREC rules apply to you. So let's cover the Real Estate License Act, and this is essentially what Senate Bill 2212 did, which went into effect last year. And I'm just going to put this all on the screen so you can see it. So the previous is the black text, and what went into effect in September is the red text. And I'm focusing on that last sentence, which states that TREC cannot include in the rules to prohibit false, misleading, or deceptive practices a rule that requires the term broker, agent, or a similar designation or term, a reference to TREC, or the person's license number to be included in the person's advertising. So this is what Senate Bill 2212 added. This essentially prohibits TREC from requiring you to include an identifier in your advertising. So if you recall in the past, you had to use certain terms that were allowed, which if you were a broker, you would use broker. If you were an agent, you would use agents. And you could also use the term realtor. In addition to that, there was a safe harbor that was not in the rules, but you could use realty. And those 4 terms were the only permissible terms that were allowed in the past. Over time, there were questions about whether properties, management, real estate would qualify, but they did not. So Senate Bill 2212 led to prohibiting TREC from requiring any of those terms in your advertising. So the second part of the License Act that deals with advertising is here on the screen. Again, up on top is what was previously, and down below is what is effective September 1st of last year. So I'm going to focus on number 4 at the bottom. So TREC can suspend or revoke the license or take other disciplinary action if the license holder fails to include the name of the broker for whom the license holder acts, which name may be the license name, assumed name, or trade name of the broker, as authorized by law of the state and registered with TREC. So if you look up above number 3 in the previous section, it replaced that, which used to say fails to identify the person causing the ad to be published as a licensed broker or agent. The reason that was updated or amended was because there were differing opinions as to what that meant. Did that require you to have an identifier in all your advertisements? Or was that simply requiring you to include the name of the broker in your advertisement? So that's why it was amended, and 4 is what you have to have, which is the name of the broker. And then 3 was added, implies that a sales agent is responsible for the operation of the broker's real estate brokerage business. And that's already in the rules, but it was codified in the statute. So again, these are the only 2 sections that are in the License Act that deal with advertising. Now, although the identifier requirement was removed from the statute, and at a meeting, I believe in August, TREC also removed it from the rules. They have had emergency adoption to remove the identifier requirement from the rules as well. Article 12 of the NAR Code of Ethics still requires you to have your professional status as a real estate professional in a readily apparent manner in your advertising. So although TREC can't require you to include those terms, the Realtor Code of Ethics under Article 12 still requires you to have a professional status. And I'll get into what's acceptable later on in the presentation. So let's get into the rules. So the rules that go into effect in May have several new definitions. The first one is that an advertisement is defined as any form of communication by or on behalf of a license holder designed to attract the public to use your real estate services. So this is very broad. Anything that is, it can be written or oral that's designed to attract the public to use your services can be considered an advertisement. And this can include publications, brochures. I think we may have a question.
It says, are there any discrepancies regarding identifying an agent as an associate broker in their advertising?
And we'll get to that in just a second. One of the new definitions defines associated broker. So I'll get to that in just a second. So advertisement can also include radio or television broadcasts, electronic media, including email, text messages, social media, internet. So if you're questioning whether something on Facebook or Twitter is an advertisement, here it is included in the definition. It can also include business stationery, business cards, displays, signs, and billboards. One of the questions we have received in the past is whether a for sale sign in front of a property is considered an advertisement. And TREC has stated if it has the broker's or agent's name on it, then it is considered an advertisement and would therefore have to comply with advertising rules. So again, the definition is pretty broad. Now, are there any exceptions? There's only one exception under the new rules that go into effect in May, and it's communication from a license holder to the license holder's current clients. That is not considered an advertisement. So if you're sending an email to your current client, that's not an ad. But if you're sending an email to a consumer that you're trying to attract them to use your services, that is going to be considered an advertisement. Again, there's only this exception under the current rules. So again, if you do get confused when I'm referring to new rules versus current rules, let me know. But under the current rule, there are 2 exceptions. The other exception is information. This is one of them, the communication to a license holder. The other exception under the current rules is information behind a firewall or information on a website that's password protected. That exception is going away come May. So here we get into some other definitions. The new rules define broker's name and contact information. So broker's name is defined as the name on the TREC license, or if you're an individual, it could be an alternate name that's registered with TREC. In addition to that, it can be any assumed business name that meets certain requirements, and we'll get into those in just a second. Contact information is defined as any information that can be used to contact the license holder featured in the ad, and it can include a name, a phone number, email address, website address, social media handle, scan code, or other similar information. And the reason contact information is defined is because that's how you're going to measure how big the broker's name needs to be. So for example, if you have the agent's name is the largest information on the advertisement, that's what you're going to need to measure the broker's name against, that agent's name, because it's the largest contact information on the advertisements. We're getting into some more definitions for alternate name, associated broker, and assumed business name. So an alternate name is an alias. It's a name used by an individual license holder other than the name shown on the TREC license. It can be a middle name, a maiden name, or a nickname, but it won't include something that TREC calls a common derivative. So if your name is William, Bill is short for William, that's what TREC considers a common derivative, or Kim for Kimberly. Those common derivatives do not need to be registered, but an alternate name, which again can include a middle name, maiden name, or any other name used that's not on your TREC license, will have to be registered with TREC prior to you using that name. TREC can also require supporting documentation showing your authority to use that name if the last name is different from the name on your TREC license. Next step on the list is associated broker. An associated broker is a broker who associates with and gets paid through another broker under a relationship that's intended to be continuous, including but not limited to an employment or ongoing independent contractor relationship. So here's where TREC starts to define associated broker. If there's a broker within the office, but they're not the broker of record, they're not the designated broker, they're going to be considered, and they do have a broker's license, they're going to be considered an associated broker. Next up is assumed business name. An assumed business name is essentially a DBA or a trade name, and it's any name used in business by a broker that meets certain requirements. It's other than the name on the broker's TREC license. It's not a team name or an alternate name. So again, it's not a team name. Team names are distinguished from assumed business names. Requirements for assumed business names, those also have to be registered with TREC. The broker must register this. And there's a 10-day notice requirement to TREC if it's no longer used. The broker must provide written evidence of legal authority to use that assumed business name. So those are all the definitions. We're going to move forward into do's and don'ts. I've tried to break up the rules into simple do's. So anytime I refer to the general requirements of the advertising rules, I'm talking about these two components. So in every advertisement in the new rules, you have to include the name of the license holder or the team placing the ad and the broker's name. So even though you have a team name in the ad, you're still going to have to add the broker's name. And same with the agent's name, or if you're an associated broker, you're still going to have to add the broker of record, designated broker's name. So keep these two components in mind when we're talking about the general requirements. These always have to be on the ad. And this again goes into effect May 15th. Currently, all you have to have is the broker's name on the advertisement, but going into effect in May, you would have to have those two components. What about locations or size requirements? Remember when we talked about contact information? So there are requirements. The name of the license holder, so let's say the agent or associated broker, or the team name must be in a readily noticeable location on the advertisement. In addition, the broker's name must be at least half the size of the largest contact information. So that example I gave earlier could be of the sales agent, associated broker, or team name. You would measure the broker's name against the largest contact information on the ad. And then do's for the code of ethics. You have to portray a true picture. You have to ensure that your status is readily apparent. And so remember at the beginning we talked about, although TREC can't require you to use an identifier, Article 12 of the NAR Code of Ethics does require you to have a status. So how do you meet that requirement? It can be accomplished by including the terms realtor, realtors, disclosing your status as a licensed broker, appraiser, property manager, or other real estate professional. There's no list of items that would be approved, but this is how you can accomplish that. Going back, you do have to disclose the name of your realtor's firm. So if you are a broker and you put your individual broker's name on an advertisement, under the Code of Ethics, if there's a firm name, you still have to include the firm name to comply with Article 12. What about team names? Would a team name be sufficient for a firm name? And I know this is tiny, but I'm just going to zoom in. So a team name is not going to be enough for the firm name under the NAR Code of Ethics. And then just pointing to Article 12, here's where you get the true picture test. And that true picture test does extend to URLs and domain names. One example from a while back was an agent had their city MLS, they had the city plus MLS.com. So the public thought that that was actually the city's MLS or the board's local MLS. So complaints were filed because it did not meet the true picture test under Standard or Practice 12-10. So that's just an example of that. And then again, the status as a real estate professional. And then having the realtor's firm comes from Standard or Practice 12-5. So the one doubt we have is don't publish advertising that is deceptive, misleading, or implies that a sales agent is responsible for the operation of the broker's real estate brokerage business. I believe we have a question.
Someone asks, we have a team that has a broker's license. Will that need to be updated because of the new team rules?
So if the team is actually a corporate broker, TREC is going to see that. As if it has a business entity license, TREC is going to see that as a corporate broker. Now, if that team does not have a business entity license, that's going to be, that we'll have to comply with the team name requirements, and I'll get into those in a second as well. Okay, so again, the one don't seems pretty simple, but how do you actually avoid that? And this comes from the Real Estate License Act. Okay, so the TREC rules actually define what could be considered deceptive or misleading, so let's get into a few of those. There's a list of, I believe, 20, but we're only going to go through certain ones. Advertising that's inaccurate in any material fact or representation. Misrepresenting square footage could be an example of that. Advertising that identifies a sales agent as a broker. Advertising that uses a title such as owner, president, CEO, COO, or other similar title, email, or website address that implies a sales agent is responsible for the operations of a brokerage. Now this is important because I think this comes up a lot. Even though you're a sales agent and you may actually have this title, let's say, for instance, you're the president of the company, for TREC advertising purposes, you cannot advertise that even though you legally have that title because it would imply that a sales agent is responsible for the operation of the brokerage. So keep that in mind, that could be deceptive or misleading even though you legally hold that title. Advertising that contains a team name with terms that imply that the team is offering brokerage services independent from the broker, including but not limited to realty, brokerage, company, and associates. Now I have realty highlighted here because TREC is actually going to reconsider the list of prohibited terms, specifically realty. So they're going to reconsider limiting that, and realty will be permitted, but that will be determined at the upcoming May meeting. Advertising that contains the name of a sales agent that is not the name as shown on the sales agent's license or an alternate name registered with TREC. So this is why it's important to make sure that every name you're going to use is on file with TREC. The list goes on. Advertising that contains the name of a sales agent whose name is in whole or in part used in the broker's name and that implies that the sales agent is responsible for the brokerage. So what does that actually mean? An example of this would be, for example, if you have Jane Smith as a sales agent and she's sponsored by Smith Realty. Not her company, but Smith Realty is owned by John Smith, who is a designated broker for Smith Realty. Because her name is included in her broker's name, Smith Realty, TREC could see that as misleading or deceptive. So in that example, TREC has suggested that she add the phrase sales agent so it does not give the impression that she's responsible for Smith Realty. I think we have a question?
A couple. All right, so someone asks, don't you have to disclose to the consumer that you have an interest in the company? In other words, do you have to disclose to the client that you are the owner of a company?
Yes, that is correct. That's not under the advertising rules. That's in a different section of the rules, but you do have to disclose when you have ownership interest.
But that's not in advertising, that's just in conversation with the client?
You have to do it prior to written contract, is that correct? Prior to submitting an offer?
Prior to execution.
Prior to execution
But
of the contract.
Not on your signs. And then someone says, this rule defines alternate name, associated broker, assumed business name, and team name. Each type of name must be registered with TREC before the name can be used in an advertisement.
That's correct. Associated broker does not need to be registered, but everything else does.
So may association staff submit changes to internal systems without the name being displayed on the TREC website based on the member stating that they have sent the information to TREC? So I guess that means in their membership, I think Terry's asking, can association staff change their membership record if to those names if they have not been registered with TREC? Is that correct, Terry?
Well, the membership record would be a different issue, separate and apart. I know they tried to track it with TREC, which is fine. You may want proof of that. So there's nothing wrong with waiting for that to be registered with TREC, but again, they're separate and independent. And then going back to the last question, Article 12 also requires a disclosure of ownership, even if it's unlisted property or you have any ownership interest, as well as Article 4 as well has certain requirements similar to the TREC rule. And then advertising about the value of a property unless it is based on an appraisal that's disclosed and readily available upon request by a party or it's given in compliance with 535.17. So if you recall back in December of 2015, TREC put out an advisor that cautions license holders from using the term value. That scared many of our members because opinion of value is essentially the definition for an appraisal. That's why TREC was cautioning our members from using that. But you are not prohibited from using the term value. If you do, however, in an advertisement, you do have to include the language in 535.17, which I'll put up on the screen in just a second. So again, anytime you're advertising about the value, if you have an AVM automated valuation model on your website, you need to make sure you have the language in 535.17 so it doesn't violate this section. About a property that's subject to an exclusive listing agreement without the permission of the listing broker and without disclosing the name of the listing broker unless the listing broker has expressly agreed in writing to waive disclosure. I know most of you may be commercial license holders, but if any of you use the local multiple listing service, that would be in compliance with this. The MLS has IDX rules that allow you to advertise other brokers' listings. And the MLS rules have the consent already built in, as well as disclosing the name of the firm. But if you're not using your MLS and you're going to advertise on Craigslist, whatever it might be, another website, and you're not getting it through the MLS, you still need to make sure you have permission and you do disclose the name of the listing broker if you're going to advertise other brokers' listings. About a property 10 days or more after the closing of a transaction, unless the current status of the property is included in the ad. And then I've just written them simpler here under sales agents, the ones that apply. If you identify a sales agent as a broker, you use certain titles. Contains the name of a sales agent that's not the name on the TREC license or registered with TREC. And then that Jane Smith example contains the name of a sales agent whose name is in whole or in part used in the broker's name that implies the sales agent is responsible for the brokerage. So let's get into social media and text messaging. Do you have to comply with the advertising rules when you're using social media or text messaging? We already answered that in the beginning. Remember, the definition of an advertisement is pretty broad and it does include social media or text messaging as long as you're putting information out there that you expect or are trying to attract the public to use your services. So how do you comply with this rule? So the required information, if you remember, going back to what are those two components, the name of the license holder or team placing the ad and the broker's name. So those two components, may be located on a separate page or on the account user profile page of the license holder if the separate page or account user profile is readily accessible by a direct link from the social media or text, and that information is readily noticeable on the separate page or in the account user profile. I believe TREC is going to put out more information on how to actually comply with this when you're using social media, and TAR may be putting a flyer together on this as well. So team and names. How is a team name defined? A team name is any name used by a group of one or more, yes, it does say one or more license holders sponsored by or associated with the same broker that performs real estate activities under an exclusive collective name other than the broker's license name or assumed business name. So again, team name is different from assumed business name. They are not the same thing. This becomes important if you've heard of expansion teams where you have two agents under different brokers working on a team. That's not going to comply with this TREC component because it says license holder sponsored by or associated with the same broker. So what are the limitations on use of a team name? Did you have another question?
There is one, but go ahead and finish with team names and we'll come back.
So team name cannot include any terms that could mislead the public to believe that the team is offering brokerage services independent from its sponsoring broker. And remember, those terms are realty, brokerage, company, and associates. But realty, again, is being reconsidered by TREC in team advertising. So this is a blog post from TAR, and TREC did receive feedback from many of the license holders that they're going to consider proposing a rule at the May meeting to delete the prohibition against using the term realty in a team name. So team names would be able to have the term realty. A team name must end with the word team or group. So although you could have that term realty in your team name, it still needs to end with team or group. So for example, if we had Moss Properties, properties in real estate are also acceptable. So if we had Moss Properties, in order to comply with the team name requirement, I would have to add team. So Moss Properties team would be acceptable under the new rules. It also must be registered with TREC prior to an associated broker or sales agent using it in an ad. And then if a broker agent or associated broker agent stops using that team name, the broker must notify TREC in writing not later than the 10th day after the date they stop using it. So if a sales agent leaves the brokerage and goes to a new brokerage and they're no longer going to use that team name, TREC does need to be notified by the broker. And we've already answered this, but let's go ahead and answer it again. Is a team name considered an assumed business name of the broker? And the answer is no. Remember that the definition for an assumed business name, it specifically excludes a team name. An assumed business name, again, is a DBA or a trade name. Means any name used in business by the broker that meets the assumed business name requirements other than the name shown on the broker's TREC license, a team name, or an alternate name. And Amy, I think you had a question.
Yes, someone asked, just to be on the safe side, can we request someone to review our website to make sure we're in compliance?
So I have a FAQ at the end. TREC has stated they will not review advertising for a sales agent. It's unclear if they would do that with a broker, but I think they will discuss the advertising with the broker. You can also call the TAR legal hotline. Although we cannot approve your advertising, we can point you in the right direction or let you know if you're missing something on the advertisement. Going back to that value, if you have an advertisement that misleads or is likely to deceive the public or tends to create a misleading impression, or imply the sales agent is responsible for the operation of the broker's real estate brokerage business, includes but not limited to an advertisement about the value of the property, unless it's based on an appraisal or it has the language 535.17. So what is that language? The new required disclosure statement needs to be reproduced verbatim in 12-point font, sorry, not 10-point, 12-point font. And here's the language that would need to be on that. Anytime you're using the word value in an advertisement, it would have to have, this represents an estimated sales price for this property. It is not the same as the opinion of value in an appraisal developed by a licensed appraiser under the Uniform Standards of Professional Appraisal Practice. And that went into effect in December. This language has been sent to the local MLSs as well as RPR if you do print out values or CMAs from those entities. Okay, and I'm going to turn it over to Abby Lee, who's going to talk about consumer protection notice and information about brokerage services. And then I'll come back if we have time and go over some examples of some advertisements. And this is Abby Lee. She is Senior Associate Counsel at TAR. Do you want me to put the other card on?
No, it's okay. Good morning, everyone. I just have a few topics that I want to talk about before we get to your questions. First, I'm going to talk about the information about brokerage services notice and consumer protection notice. So back in November, TREC adopted changes to both the consumer protection notice rule and the information about brokerage services rule as well. Those changes became effective in December. Well, why are we talking about this now? Because TREC has made clear that they are going to be stepping up enforcement in this area. So if you are not already in compliance, now is a good time to get in compliance. So I'm sure that it's not news to you that back in February of 2016, TREC modified the requirement for both the consumer protection notice and the information about brokerage services to require that license holders link to those respective forms, either the consumer protection notice or the IBS, in a readily noticeable place on the home page of each business website. And there were specific headings for that, a specific font size. So what did TREC make changes to back in November? Well, one thing they did is they added an additional option for compliance for that website link. So the pre-existing requirement was that you had to label the link on your website as Texas Real Estate Commission Consumer Protection Notice, or if we're talking about the IBS, Texas Real Estate Commission information about brokerage services, in at least 10-point font, again, in a readily noticeable place on the homepage of the business website. That was already what was in the rule from 2016. What they did is they added an additional option. So if you want to shorten the Texas Real Estate Commission to TREC, including the same heading otherwise, but using TREC instead of Texas Real Estate Commission, you can do that as well. The only change to that is you do have to increase the font size of that link from 10-point to 12-point. So if you want to say Texas Real Estate Commission Consumer Protection Notice, that can be in 10-point, but if you want to say TREC Consumer Protection Notice, that has to be in 12-point. Another change that was made to both of the rules is they added a definition of business website. I know we got that question a lot. I know TREC got that question a lot. What is a business website? Well, the definition provided in the rule that, again, went into effect December 6th is 1, it's accessible to the public. 2, it contains information about a license holder's real estate brokerage services. And 3, the content of the website is controlled by the license holder. Now, per TREC, on that last point, controlling the content does not mean controlling the format or structure of the website. It means you control the information you input about your services or listings. That's what they're going to consider control. In providing a link on a social media platform, which could again be a business website, the link may be located on the account holder profile or a separate page or website through a direct link from the social media platform or account holder profile. So similar to the advertising requirement you just heard Kinski talk about with regard to social media. So again, as I said, this went into effect December 6th. And like I said at the beginning, if you're not already compliant, if you are not in compliance already, now is a good time to get in compliance because, as I mentioned, they're emphasizing enforcement. And in addition to the rule change to the CPM, Consumer Protection Notice, and IBS, TREC also adopted changes to the rule outlining the schedule of penalties to clarify and modify the sanctions in place for license holders who still do not properly provide the notice. And an administrative penalty range of $500 to $3,000 per violation per day may be assessed for violations of either the Consumer Protection Notice or IBS rules. So again, now is a good time to get in compliance if you are not already. The last thing I'm going to talk about just very briefly is really just an FYI, something to be on your radar, and that is the concept of a specialty certification. So TREC, in consultation with the Education Standards Advisory Committee, some of you may know that is ESAC, it's a committee that TREC has created to look at education and to make recommendations to the commission. So TREC, in consultation with ESAC, is considering the possibility of creating specialty area certifications. Right now, they're focused more on property management, but they've also talked about a farm and ranch certification, and then even possibly a commercial certification, which is why we're mentioning it today. Now, when I say certification, we're not talking about a separate license to engage in those specialties. We're talking about the right to advertise as TREC certified in property management or TREC certified in farm and ranch. Again, this is very preliminary. No rule has been proposed yet, still in the brainstorming session. And so TREC is going to take their time to vet this issue, and we'll continue to discuss that with ESAC. If any of you attended the TREC's strategic plan, listening to her, you may have already heard about that and had that discussion. So again, nothing has been proposed, but the basic framework being discussed for property management is, and I'll get to that in a second, we'll go through what they're talking about for that. And why am I talking about what they're doing for property management is that they've talked about, okay, well, if we do one for farm and ranch, or if we do one for commercial, we will likely use a similar format. So it's good to know what they're looking at for property management because, again, if they decide to do something for commercial, it may be similar. So for property management, what they have discussed, or the framework that they've discussed, is really two options. The first option is if a license holder has more experience, there may be less educational requirements. The second option is if the license holder has less experience, then there may be more education requirements. So option one, let's look at the more experience option. So if you are a license holder and you have at least 1,500 experience points in residential property management, which is about 60 transactions, then in order to obtain the certification, you would need to complete the 30-hour elective qualifying course in property management within the past 4 years and take an exam. Now, if you have less experience, where you have at least 750 experience points, which equals roughly 30 transactions, you have to take, so you have more than 700, or you have 750 experience points or more, but you have less than that 1,500 experience points threshold. Then in addition to taking, again, the 30-hour elective qualifying course in property management, you would have to do that within the past 2 years as opposed to 4 years. And you would also have to complete an additional 30 hours of CE in residential property management. So again, more education within a shorter time period if you have less experience. You have to have at least 750 experience points if you're applying, but again, if you have less than 1,500, you may need more education. And again, this is just the basic framework being discussed, nothing proposed. I think we've got a question.
What qualifies as an experience point for property management?
Well, that's something they are still discussing, and that's a great question. They do use something similar for broker qualifying experience, so it's likely in the rules, likely going to be similar to that. But one of the things they're discussing is how much points do we assign to the property management side, collecting rent? Is that 25 points? Is that 50 points? How much do we assign to leasing a property, actually going through the leasing transaction? That could be less or more points. So they're still in discussion with that. That hasn't been fine-tuned. Much like most of this, it's still at the discussion phase. And then the last part, again, so you either take more education or you don't need to take as much education. You've got the experience, and then whether you're option 1 or option 2, you've got to pass an exam. And then in order to maintain that certification, what they're discussing is perhaps requiring an additional amount of CE to be taken to maintain that certification. So that's still being discussed. Again, very much in the preliminary stage, but thought it was important to mention to you so that you can be keeping that on your radar. Any other questions? Okay, I will turn it back over to Kinski, and we will likely answer your advertising questions.
And I have one. Okay, perfect. Someone says, I am using the words realty agent in my email.
Okay,
I am a sales agent. Is this considered misleading?
and read it one more time. So they're using the words.
I am
realty
using the
agent.
words realty agent in my email. I am a sales agent. Is this considered misleading?
So that alone, just in an email, is not going to be considered deceptive or misleading. It could, if you put it in an advertisement and it gave the impression that you're responsible for the operation of the brokerage under that deceptive or misleading section. But remember, the only one that prohibited the term realty was in a team name, but again, TREC is reconsidering that, so it's not prohibited. So there's no prohibition on using the term realty. But again, going back to sales agent plus realty could give the impression that the sales agent's responsible for the brokerage, but we did recently ask TREC whether a URL or website address is considered an advertisement, and they said no, alone, if it's alone, but if it's in an advertisement, then that's where TREC can take a look at it. And I have an example here. Let me see if I can. Amy, how much time do we have so I can go through some of these questions?
We still have, we have fulfilled our CE, but we still have 10 minutes.
Okay, perfect. So let me go through, and I'll come back to these questions if we don't have any other questions.
I have a few more.
Okay, so I just wanted to point out, here is the advertising article that was in the Realtor magazine that answers a lot of these questions, and there's examples, but I'm going to zoom into this last one. So in this example, we're assuming this is an ad, and David Jones is a sales agent, and he is sponsored by ABC Realty, which does have a business entity license. And so he's complied with having his name on there, and he has the brokerage name, so his broker. And then to comply with Article 12 of the Code of Ethics, he's included his status, realtor. But take a look down here. In the advertisement, he has David Jones, CEO at abcrealty.com. Remember that one rule about deceptive or misleading, if you have certain titles in your sales agent, that's where that can be deceptive or misleading, because this is included in the advertisement, David Jones CEO or www.davidjonesceo.com. So although it has the other requirements, it's not going to meet all the requirements because it could be deceptive or misleading by using that title in the email address or website address. I think you had more questions.
Yep. Are the team and group leads required to be delegated as supervising license holders if shown on the IABS?
Are they required? required to be?
Are the team and group leads required to be delegated as supervising license holders if shown on the IBS?
No, there's no requirement for that yet. Or anything going into effect in May, so there's no requirement for that.
Okay.
If you are a team, you do have to, again, have the broker register that team name with TREC. And there is a form, let me give that to these, just so you can see the new forms. Earlier, somebody did ask whether TREC would review your advertising. If you're a sales agent, the answer is no, but they can discuss advertising questions with the broker. And then let me give to, so here's the notice of alternate name. So if you're using your maiden name or middle name, you would use that form. But if you're a team name, and then going backwards, here's the form that you would use. Just so you can see that form was created January 1st of this year. You will be required to use this for all team names come May 15th. And one thing to mention is if you have a team name that was already registered with TREC as an assumed business name, but it actually is going to be a team name and meets the team name requirements, it's not going to be grandfathered, although it may already be registered with TREC. You're going to need to refile it using this team name form. Are there additional questions?
There are a couple more. Somebody is referring back to when Abby was talking about potential designations and asked about the property management segment. If you are a CCIM, will this be noted? I guess that would apply to any other designations.
Yeah, so that's another good question. Hello again. So one of the things during the last ESAC meeting, TREC actually put together sort of a preliminary draft of the rule. And one of the things that they did talk about was whether or not existing designations or certifications could receive credit. And so CCIM was one of those existing certifications designations that was included in that list. So again, I think that's the direction they're thinking, but we have nothing finalized yet.
All right. Well, while I have you, Abby,
Yes.
there's one on IABS CPN requirement. On our broker website, there is a link to each agent's LinkedIn profiles. On the LinkedIn profile for our brokerage, we have a link to the completed IABS and CPN forms on our company website. Do I need to provide a link to these forms on my own LinkedIn profile as well?
So the question is whether that constitutes as a business website. And remember, social media can be considered a business website. TREC has some guidance that they put together about basically, what is a business website. And it's basically anything that you are using to advertise your services or to provide information about property. It's very general. So I think if there's a question as to whether something is a business website or is not, I would err on the side of caution and consider it a business website.
All right, now I have a few more back to advertising. Someone says, can I use the word realtor after my name, or does it have to be something else? So realtor as an identifier.
That's a good question. TREC is not going to recognize the term realtor. So if we're talking about the TREC advertising rules, remember they no longer require the identifier, which realtor used to be one of those acceptable terms. TREC no longer requires that, so TREC does not recognize realtor. But for purposes of Article 12, including the status, your professional status, you can use the term realtor as long as you're a realtor member. You do have to follow the proper rules of using that trademark, such as proper punctuation, and it can be used in connection with your personal name or firm name, but it cannot be used with a team name at all. So for example, let's say you have, what was there an example?
Well, it was our friend Sonia Luna. And she
Sonia Luna,
uses realtor.
she can do Sonia Luna, comma, realtor, because she has to use proper punctuation with that term. One thing also I'm going to mention about the use of the term realtor, it can be used in connection with the personal name and in connection with the firm name, but it cannot be part of. So what we've been seeing lately is a lot of brokerages or firms have filed the term realtor in their actual name with the Secretary of State, and that is not permissible under the NER trademark rules. So you can use it in advertising by using comma realtor, but you cannot file that as your actual name. And we should have more information on those rules coming out in the next magazine.
Okay, so someone sincerely apologizes if they're being repetitive, but I think a lot of this bears a lot of repeating. It's very confusing. Can an agent advertise as an associate broker if they have their broker's license but is not the designated broker?
So as long as they are a broker associated with another broker, they can use the phrase associated broker. And in this article, there was an example, the last one, and I think I can go to it and zoom in, where TREC actually does suggest, and let's just go through that example so you can see it. So yes, if you're a sales, if you have a broker's license but you're associated with a broker, then you're considered an associated broker, and you can advertise as associated broker. But be cautious, because if you just put broker, TREC's going to see that as deceptive or misleading because you're not the designated broker, but associated broker would be okay. So in this example, you have Christo is the associated broker, and he's associated with his wife, Jane Doe, who is a designated broker of the brokerage entity. And they've registered Doe Realty as an assumed business name for the brokerage entity. So in this example, you have Christo, who is a broker associate, comma realtor, so there he's using the professional status to comply with Article 12. And then he has Doe Realty. So he has his brokerage entity, or the assumed business name of the brokerage entity, Doe Realty. However, because it includes an assumed business name registered with TREC, the ad is not in compliance because this could imply that the associated broker is responsible for the brokerage because he is an associated broker, but Doe Realty, the designated broker for Doe Realty is actually Jane Doe, his wife. So TREC has actually said this could be deceptive or misleading, so they've suggested that you add associated broker to the ad. Or if Christo was an agent, he could add sales agent to that. Any other questions?
So someone has a statement. I don't understand why TREC thinks the general public thinks terms like CEO, VP, or president implies that the person actually owns the company. Most companies who have these executives with these titles does not mean they own the company. And I think the answer is that's just what TREC thinks.
Just leave that as a statement.
Do we have any more questions for Kinski or Abby? Oh, Brownsville is, can you unmute them?
Yes.
Brownsville's waving.
Hold on, they have to.
All right, you're good to go, Brownsville, we can hear you.
The question is, broker associate is the same as associated broker?
So the question is whether broker associate and associated broker are the same thing. It can be as long as they have a broker's license and are associated with another broker. But if you look, I think it's our listing agreement that says brokers associate, which is could refer to a sales agent as long as they have authority to sign it. So when you're advertising though with associated broker or broker associate, TREC has specifically defined associated broker, so that might be preferred. But what you really need to do if you're advertising under those phrases is make sure that you actually do have a broker's license and you're associated with the broker of record.
Better associate, so do we get the definition?
It's better to use associate.
Okay.
Okay, thank you.
Thank you. Any other questions from the audience?
Yes.
Go
Let's
ahead.
do another. Okay, so if they don't have the team registration file, Is it the broker that's in violation, or would it be the team itself, or both?
I think it's gonna go for the broker, because the broker's the one that has to register the team name.
Okay, and what statute do we cite for, or we just file a regular complaint? What do we reference to?
Against the agent who has a team name. Sorry, what was the second question?
What is a violation? What's the section that we refer to
For penalties,
for the failure to register the team?
let me think.
Or is it just a general complaint?
There's listed in the penalties section.
Yeah, I don't have this section number written down. There is a specific schedule of administrative penalties in the TREC rule where they kind of have catch-all categories if it's not specifically mentioned, but I do believe the advertising rule has been added specifically. So if you
email me, I can send that to you. We don't know it off the top of our head. And if
You
you have
memorize the entire
sorry.
code, guys? Come on.
if you have any questions that come up later, feel free to email me. My email address is on the screen, or you can contact the legal hotline. Thank you again. If anything comes up, let us know, and Amy's going to conclude the presentation.
All right, guys. Shoo. Okay. I'm very, very glad we have attorneys to keep track of this because I sure can't. Thanks, guys, a lot. It's really, really helpful. A lot of people asked about the link to the recording and the slideshow. We will have those posted. Hopefully by the end of the week, I will put some things out on the website and on our Facebook group, which reminds me, hey everybody, we have a TAR commercial Facebook group now, so we'd be delighted if you join. We're using that to keep track of events and post classes and things like that, so go to Facebook and look us up and ask to join, and we'll be happy to connect you to other realtors around the state. Our next webinar is going to be May 15th, and that webinar is going to be a commercial forms update done by Rick Albers, who's another attorney a lot of you probably know. He's going to go over changes to the existing commercial forms and the new commercial forms that were published this year. The webinar will also be available for CE, just like this one, if you view it at a proctored location like you've been doing here today. If you contact your local board and they are not interested in showing the webinar for CE, you can do a remote classroom like our friends at Freedom Title Southlake and Gad Medford Real Estate. If you're interested in setting up a remote classroom, you can reach out to me, or you can reach out to John Hauser in our professional development staff here at TAR. We'll be happy to get you set up. And I will be also posting that registration link on the Facebook page and sending it out to our commercial audience in an email. If we don't have any more questions, I think we will wrap up for today. Thank you everybody for helping and taking part. We appreciate you taking the time out of your day. And that's it. We'll see you next month. Everybody take care and have a great day.